Clint Brown with Roberts Markel Weinberg Butler Haley, and today we are going to be focusing. There's some COVID questions thrown in there, but it's going to be more of kind of an Ask the Expert Q&A. We've received a multitude of questions we're going to be addressing today, but as we kind of roll through this presentation, if you've got a question, you have two options. You can either just type it in through the Q&A, or you can basically do a hand raise. So there should be a hand raise somewhere on your screen. You simply raise your hand, and our moderator, either Lindsay either Kyle or Sarah, will kind of unmute you so that you can ask your question. So hand raise will allow you to do an audio question, and then the Q&A would just allow you to kind of type it in. So with that, let's go ahead and get started. First and foremost, we've got our disclaimer, our legal disclaimer. Generally, it's based upon the law in Texas and nationally as it exists today. As you know, laws can change, whether it be on a national or Texas level. So our opinions can change based upon both law and how the courts rule in a court case, number one. Number two, as it relates to COVID-19, our discussions on COVID-19, again, it can actually change on an hourly or daily basis. What we discussed today at 11:30 could really change today at 4 o'clock, 5 o'clock next day. So keep that in mind when you're listening to this information. It's still important for you to be plugged in, because the advice I'm giving you now could very likely change the next day. So let's dig right in to our first question. What is the best way to protect the HOA from a legal blowback if we choose to enforce a car towing policy? Really good question. I'm gonna interchange that term HOA with POA. So HOA is a term of art that really just refers to single family communities and then townhome communities that are governed by Chapter 209 of the Texas Property Code. Whereas a POA, that term of art, covers condominiums and single family. So POA covers everybody, condos and single family. So what do? We've got a car towing restriction that gives the association the power to tow vehicles within the community who violate who violate the restrictions or this car towing policy. The first thing you've got to look at is, are you a private street community? If you're a condominium, the answer is yes. Your roads are your roads if you're a condo. So it's a very easy answer there. But for single family, you've got to ask, number one, are we gated? And if the answer is yes, then those streets are yours. Or if you're not gated, the streets could still be yours if you're way out in the county somewhere without any kind of municipality control and the county hasn't accepted your roads. So those are really the two ways that you are a private street community if you're an HOA. Now, the next question is, why does that matter? It matters because if you are a public street community, you cannot tow. So if your streets, for an association you represent or you're on the board, if your streets are public, then you have no towing authority. So do not tow in those instances. Make sure you reach out to your legal counsel to confirm that's the case, but that is the general rule of thumb. So we're assuming we're private streets and we've got this towing authority in our governing documents. What's the best way to avoid blowback when we start wanting to enforce towing in this type of community? The best way to do it, I've found, is to do one or more of the following things. Either have kind of an e-blast out to your community, maybe a month or 2 months prior to you wanting to implement this towing, and just kind of as an FYI, hey, FYI, the association is going to start more strictly enforcing its parking rules and regulations for the community. Maybe give an explanation as to why, parking has become a big problem. We had an incident where an emergency vehicle was unable to effectively access the community. Whatever the case may be, let them know that you're going to start enforcing this towing policy more stringently, which includes towing, and then give a reason why. So an e-blast, that's one effective way to do it. Another effective way to do it is to kind of mention it in your board meetings that you have, that you're going to be implementing it in the next 2 to 3 months. And then thirdly, I've seen some communities hold a town hall. If it is a big enough of a problem, then maybe hosting a town hall to discuss ways to basically effectively enforce the parking restrictions in the community, that could prove beneficial as well. So again, getting ahead of the towing is the most important thing to do, so that your owners aren't kind of, caught deer in the headlight type scenario and I had no clue X, Y, and Z. And look, you're still going to get those owners that said, I had no clue, nobody told me. But hopefully that will lessen the impact so you don't get as much of a social media blowback. And if and when you do get social media blowback, after you've done all that, you've anticipated it, you've gotten an e-blast out to the community, you've had your town hall, you've spoken about it in board meetings actively, and you still get a heavy blowback, well then you may have to consider a follow-up email blast. And if you're utilizing social media, you kind of put together a good social media response as well. So that's our towing. Next question. What is the best practice regarding allowing contractors to access common areas / green belts / HOA fence line for large projects, i.e. pools, at an HOA member's home? Man, this is a very, very tough question. And what I recommend doing is drawing up some legal documents. Basically, draw up an easement access agreement that, or some sort of short-term license, something along those lines, that grants the homeowner and the contractor access within a kind of stated duration of time for them to get in and do what they need to do, and add a lot of requirements to that in terms of bringing the common area back to its original state. There's more than likely going to be some irrigation lines in the common area, so make sure that all the damage that's done has to be repaired. And then thirdly, I've had some associations, and look, if you can do this successfully, require some sort of a damage deposit, right? So the owner actually puts money in the bank that we hold, that the association holds, that can be drawn on to satisfy any kind of damage that occurs. And then of course, fingers crossed, you've got fining authority so that you can fine if any of the conditions you lay out and the owner agrees to are violated. So having the proper paperwork in place is pretty important. So again, you're going to have to get your counsel involved to address that. And then we've got one hand raise from Miss Wass. Kyle, can you unmute Allison? Allison, you are unmuted.
Oh, thank you. This doesn't have to pertain to this PowerPoint question. Should I wait until the end?
No, you're welcome to ask away.
Okay. Well, my question is, when you have other board members who have decided that perhaps a waiver for the COVID situation for the pools and the playgrounds and stuff, and they've gotten a lot of blowback on social media, and now they want to start to shop lawyers to try to get a answer on how to make them look better in the situation. How do the other board members who don't support this show their not compliance, but they're not going to go along with it? Do you do it in an open session and have it on record saying that you're not going to be part of this lawyer shopping, or what? How do you handle that?
Yeah, so it's a good question, Allison, and it's a little, it's pretty difficult. So opinion shopping is also is always a little bit tricky, because you get legal advice from one attorney, and he or she is recommending you do X, Y, and Z. And if the board doesn't like that answer, for whatever reason, they want to get another opinion, right? You get the second opinion. And that's not necessarily a bad thing if that's what the board as a whole wants to do, but it can get you into a bit of a precarious situation when you've got attorney number one recommending you do, X, and then you've got attorney number two recommending you do Y, right? So you've got a conflict in recommendations, and then the board is left with a choice. How do we handle this? Do we decide to stick with our attorney's, our general counsel's original opinion, or do we go with the opinion of this new attorney? And, there's repercussions if you decide to go with the new attorney or the old attorney. But in terms of the board members that do not want to basically shop for an additional opinion, if it's been voted on and you've got a majority of the board voting in favor of that second opinion, then I think, if you want to basically levy a dissent, make sure you levy it in potentially email format, and then bringing it up in the open session is tricky, right? Because if it's attorney-client privilege communication, you really should not be bringing up during the open session. But I think at a minimum, you can probably have a productive conversation during the executive session, so that you're not divulging any attorney-client privilege communication. So again, I think levying it, via email maybe is a good option, but you've got to be wary of the attorney-client privilege, basically breaching that, and then discussing it during executive session. As it relates to open session, it really kind of depends on what kind of discussion it's going to be, because you've got to walk that fine line on what is protected or privileged and what is not. But a good question. All right, so we've got a couple more here typed in. One from Crystal Avendano. If a board does not want to have an annual meeting, if they are not comfortable or unable to use Zoom or electronic meeting, how can a manager handle this? Okay, so we've got an annual meeting. The manager says, look, because of the orders in place, or because we can't have it outdoors, let's consider having a virtual meeting. Number one, it's more than likely going to be allowed regardless of whether you're an HOA or a condominium. But if the board comes back with, no, I don't want to, it really depends on how the bylaws are written. If the bylaws give the board flexibility in holding annual meetings, then I think maybe you can push it off for a little bit to see how our social distancing and kind of shelter in place orders are developing over time. But if it's pretty strict and we've already missed maybe 3 or 4 months due to the COVID-19 outbreak, then, Crystal, you may need to get your counsel involved to give some advice on kind of interaction between the bylaws and then corporate governance generally, and some of the ramifications the board could be facing by failing to call the annual meeting. So unfortunately, I'm going to give you and it depends question. It really is kind of specific to the community and how the governing documents are written. But again, good question. We've got another question from, let's see here, from Jennifer Mandel. We have a pool vendor in Houston who has informed the associations it serves that the new face mask order applies to the HOA pools. However, the order says it applies to businesses that directly serve the public. So the question is whether this type of order would apply to an HOA pool that is not open to the general public. Thank you. Jennifer, we've been battling this over the past 4 or 5 days, and Harris County's got a kind of a similar order for Travis County. and the Austin area. And basically, we had a Harris County attorney say that it applies equally to community associations. So, the short answer is figure out which county you're in, and more than likely it is going to be a mandatory type option, except when you are actually in the pool. But it's ever changing. City of Austin was a little bit more wishy-washy on their response and didn't really, I don't know that they understood the question or how we asked it. But right now it's probably a good idea to get with your counsel, or if you want to reach out to me offline, Jennifer, and tell me what county it is you're concerned about. Oh, actually, it's Houston. So yeah, so sorry, Jennifer, Harris County, the attorney said, yes, you are required to wear face masks. So the answer is yes. We've got it from an attorney working for Harris County. So yeah, you've got to wear it unless and until you get in the pool. Another question: what has been your experience on damage to HOA landscape from uninsured motorists? We have filed a police report and have identified the motorists. Very good question. And the answer is, basically uninsured, make sure a police report gets filed, and it looks like you've got one. The next option is, do you want to waste funds on having your attorney send a demand letter to the uninsured motorist? Right? The police are going to do what they're going to do criminally. Whether or not they pursue it is up to them on the criminal charges for not having proper insurance. But from the civil side, I've got some associations that are happy to spend a couple $100s to get the attorney to send a demand letter to the uninsured motorist to try to get money back for the damage to the common area element, whatever it may be. And then I've got the other associations that are just like, you know what, let's file it with our premises liability or our insurance and get coverage and just go about our day. So George, it depends on what you as a board want to do. I will say that many times if you are dealing with an uninsured motorist, they don't really have the funds to pay for insurance, and probably don't have the funds to pay for the damage. Again, there are exceptions to every rule, but y'all just got to weigh it. And it's, if the board wants to spend some funds to have their attorney send a demand letter, I think that's okay. And I've seen that done plenty of times. All right, so those, looks like we've gotten all of our hand raises and questions out of the way. So let's move on to the next slide. All right, so this next one is a very good question. Has there been progress of U.S. House Bill 6800, and what is the likelihood of it passing with the HOA collection language intact? So very good comment. I wrote an article on this a few weeks ago, and what this House bill does, if it made it through the Senate, which I will say from everything we've heard, it's unlikely that it will. But if it does, then it would basically place a moratorium or a freeze on any type of kind of debt collection and foreclosure, which, as you know, for a community association that is a nonprofit, it would put us into kind of dire straits pretty quickly, unless you had a very robust reserve account that you're willing to draw from and pay back. So, as it stands, as that House Bill 6800 stands now, from what I understand, it is not making much progress in the form where debt collectors would be frozen. But again, they're negotiating. They're trying to get that second stimulus check out there. So this debt collector freeze was kind of attached to the stimulus check, the second round of stimulus checks that I'm sure you've all read about. And so they're trying to kind of separate that out and negotiate it in the Senate right now to get something passed. But as it stands now, we've been told that it's got a low likelihood of including that HOA collection language. Excuse me. Next question. Can you provide a blanket response to residents asking for a discount on their assessments in exchange for the time they were not able to access the facilities due to COVID-19? Comparing facilities to public gyms, pools, and parks. Well, you know, the response I always recommend managers give, and again, you need to confirm that this is accurate, is that the association is actually not experiencing much, if any, of a cost savings, and is probably having to pay more money in the event you're reopening pools at these limited capacities as established by Governor Abbott. So the answer is we're not saving any money, and even if we are, it's very low, so that you're not entitled to a refund. And regardless, you may not even have the authority as a board to issue refunds of assessments. You've got to have that authority in your governing documents. So if you don't have it there, it is not going to get you what you need in terms of in terms of a refund to associations, or excuse me, to the members. And look, if the board really wants to consider it, then what the association needs to consider doing is during budget season in the fall, when you're preparing your budget, maybe, you know, if there was significant savings, you consider a reduction in assessments for the following year rather than a reduction right here and right now. Because I guarantee you, for most community associations, the savings you're going to be giving back to the owners is maybe $20 per household, right? So we're not even talking about a lot of money going back to the owners. But good question. It looks like we've got a couple more Q&A that popped in from anonymous attendee. So if Harris County's mask requirement applies to pool areas, can I assume that it applies to all common areas, such as high-rise lobbies, and we are subject to fines? So again, for Harris County, from what we understand, yes, it does apply to pools, common areas, all that good stuff, that mandatory mask requirement. So yes, you could be subject to fines. Again, it's developing. Maybe Harris County is going to change their tune, because it is a little bit unclear, but from the response that I read from Harris County, yes, it applies to common areas. Good question. Can members of the community sue the association or board for not opening the pool during this time of coronavirus? Shadana, good question. And the answer is, yeah, of course, right? Anybody can sue anybody for whatever reason, but more than likely, you've got very strong words or wording in your declaration that basically says, hey, an owner has an easement of enjoyment over the common area, subject to the right of the board of directors to basically implement rules and regulations governing the use of the common areas. So the board has this authority to govern the common areas. And if it is making a decision to keep them closed due to COVID-19 and the difficulty in implementing the percent usage cap and the social distancing requirements, then that's okay. And I think you're making a good decision. And even more so for condominiums, 82.102 of the Texas Property Code gives the board a statutory right to regulate the use of the common areas as well. So again, yes, a lawsuit, you know, the owners could get together and sue the association if they wanted to. But likewise, if you did open the pool, a group of owners that didn't want to see it open could sue the board for opening the pool, right? So it's kind of a darned if you do, darned if you don't scenario. But if the board makes an educated decision, you know, based on management advice or legal counsel advice, or the state of just, you know, difficulty in enforcing the restrictions, then I think that's okay. Again, your governing document language is kind of important for you to review as well, though. All right, next question. If we have our HOA lawyer telling us not to open our amenities, playground, pool, and our insurance company has stated that they will not cover COVID-related lawsuits, Does it breach fiduciary duty to open anyway? We cannot really afford to follow state guidelines for monitoring, cleaning, etc., getting nasty social media blowback that will not listen to reason. So very good question. If you're getting advice not to open unless you can effectively enforce the, distancing and the cap, and you've got your insurance, and Grady, I'll tell you, almost every insurance company is going to say there's going to be no coverage, and then the board makes a decision not to open the facilities. Can you get in trouble? Is there going to be a breach of duty if you open anyway? So first and foremost, Grady, fiduciary duty, it really depends on if you're a condo or a single family. If you're a condo who was formed after 1994, January 1st of 1994, the declaration was filed after that date, then you do have a fiduciary duty. If, however, your declaration was recorded before January 1st, 1994, if you're a condo, or if you're a single family, you do not have a fiduciary duty unless, of course, your governing documents say otherwise. So, Grady, in terms of your standard of care, it depends on the type of community you're in. But ultimately, yeah, there is some concern there if you go against legal counsel advice and you open it kind of at a swim at your own risk type scenario. And look, there may be some attorneys out in the industry that are saying it's okay to do swim at your own risk because you don't provide for the health, safety, and welfare of the community. And as long as your governing documents say that, I understand that argument. But how do you enforce these rules and regulations that the state and or county has put in place if you're not monitoring something that is under your care, custody, and control? So the pool is under more. If you're single family, you own the pool, so you are the operator. If you're a condominium, you may not own the pool, but you are still the operator. And so if you cannot effectively enforce these restrictions because you're doing a swim at your own risk, if you violate it and somebody turns you in, the association's going to be on the hook. So it's, it's a problem. Now you're getting nasty feedback, George. Finally, you're getting a lot of pushback from your community. Well, maybe you consider levying a special assessment or asking if owners would be willing to pay the extra monies to have a pool monitor in place to ensure the rules are followed. And if the owners vote in favor of it, well, then you've done your due diligence on your end. Maybe ask them to pay the extra money. Good question, though, Grady. Thank you. George has got a, let's see here, George. George, we will discuss that question at a different time. Just feel free to reach out to me after the PowerPoint. We have another question here. This is a good one. I notice a lot of pools are opening without a pool monitor. They're self-monitoring and getting a waiver signed. Many are saying that COVID litigation won't be upheld due to the difficulty in identifying the source of where COVID was contracted. What is your recommendation for opening a pool that cannot open due to lack of funds unless they self-monitor? Is the answer still don't open it? It's a condo community, and the declaration was recorded after 1994, which means they owe a fiduciary duty, and the community owns the pool. So Rita, really good question. Should we do the say or open? And I think you raise a good point. If you do and you get sued, there is going to be a standard of care question, which is definitely concerning. But in relation to winning the lawsuit for causation, I agree. It's going to be an uphill battle for that owner that contracted COVID and sued the association because of the causation issue, basically proving that you contracted COVID at the community pool. But the broader problem I see is that you've been sued. It doesn't matter if their lawsuit is just basically frivolous and not based in law or fact. You still have to pay an attorney to defend you. And that's still money that the association has to pay for. So even though they may not have a case and you're going to win the day, you still have to pay for it. So that's my concern, is where do the funds come from in the event you do get sued? And we've already seen COVID lawsuits already across the country. So they're happening right now. So it's, you know, it's just a tricky situation to be in. Our recommendation is to keep them closed if you can't pay for proper monitoring due to that liability potential. It's just not worth it as a volunteer. You know, all the board members are volunteers, and I don't know that it's worth rolling the dice and taking that risk. But good question. And Rita followed up, the owners denied the special assessment. Well, there you have it. I mean, you left it to the owners. Hey, it's going to cost X, Y, and Z. If you want to pay for it, then we can address it then. And they decided they didn't want to pay for it. So I feel like that's kind of your answer. Let's see if we have any hand raises. I don't believe so. Perfect. Okay, let's move on. If an employee or owner has tested positive and notified the association, does the association need to release their identity? No, I would say no. Stay out of that. Let the authorities decide how they want to do it. If you're in kind of a high rise and everything, I think you could probably release certain limited information notifying the high rise that, hey, we have got a homeowner or employee that tested positive. If you're dealing with an employee, you also have some employment law ramifications you really need to think about. So, you know, if you've got this positive test and you don't know what to do and what to disclose, I do recommend you reach out to your legal counsel to figure out the best way to respond. All right, next question, virtual annual meetings. How do you handle ballots and counting of them if somebody does not mail, email, or fax in? So virtual annual meetings, we actually had a good presentation on these last week and how to do it effectively. Handle ballots and counting. So single family, you know, Chapter 209 communities, you are only required to offer at least absentee ballot voting or proxy, well, let's see, it's absentee ballot or proxy. So absentee ballots, I mean, they could be mailed in or emailed in. I mean, is that, I don't know that I understand the question. So for somebody that asked this particular question, if you want to reach out to me, I'm happy to kind of follow up with you to get more specifics. Number one, and then number two, we've got a good PowerPoint that should be available here soon for you to listen to or view. So please reach out to us, and we can get you that information. All right, next slide. When a homeowner refuses to sign a COVID waiver, stating association is unlawfully suspending their use of common area based on their refusal to sign a waiver, how do you recommend the association respond? I mean, you know, we discussed this earlier, but the association has the authority to promulgate reasonable rules and regulations. And assuming you've got that authority in your governing documents, then you are well within your rights to require owners to sign a waiver acknowledging the COVID, you know, using the pool is at their own risk. And that's it. So, you know, I think you explain it to them. If you need to do an e-blast, if you need to do a discussion at the next board meeting or a town hall, all those can be accomplished potentially with counsel involved so that you can explain the situation better. But ultimately, as long as your governing documents have that kind of authority in there, and again, you need to have the authority, then I think you're being reasonable in requiring that waiver be signed. Look, we live in an age where anywhere and everywhere you go, you're signing some sort of a waiver. You go to Six Flags, you sign a waiver. Disneyland, you sign a waiver. You go to one of those trampoline parks, you sign a waiver. You use a bouncy house, you sign a waiver. You know, any kind of activity that you want to do, you sign a waiver. And for community association, it really is no different. And community associations have that rulemaking authority. But a good, you know, good question. And again, you're probably going to have to get counsel involved to assist you in kind of developing a good response. But as long as you've got that rulemaking authority there, that's kind of our opinion. Next question: when should the association exercise a self-help remedy, and when should it not? Mowing the lawn seems generally okay. What about trimming the trees and mending fences? Yeah, so I always kind of recommend a sensical approach here. So again, mowing, doing some light trimming of trees, or mending maybe 1 or 2 fence pickets, I'm a little more comfortable with that. If you are going to be replacing 8 or 9 fence panels, the panels where there's a grouping of 10 or so pickets, I think that, that gets a little bit more touchy. So my rule of thumb is the more it costs you to do the work, the less likelihood I'm going to recommend that you actually exercise your self-help remedy. And I think self-help remedy is important to remember. You have to have the self-help remedy in your governing documents and be able to do it. So it needs to be in your declaration in order for you to exercise self-help. Because if you don't have the authority, you should not be doing it. All right, next question, or actually next slide. And we've got a question come in before we move on. Here we go. Is it too late to sign waivers after pool has been open for a month? That's a good question. And the answer is maybe. It really kind of depends on the size of your community. The larger the community, I think the more difficult it is for you to be able to backtrack. If you're dealing with a smaller community, maybe you can successfully accomplish it. So unfortunately, I don't have a good answer for you there. It really is more than likely you may be past it. But look, even if you don't decide to use waivers, that's okay. As long as the board is aware of the potential blowback from not using a waiver from a liability standpoint, and the board makes the decision not to use a waiver, that is okay. I'm not saying you have to use a waiver, period, end of sentence. We just think it's another way to add another set of kind of belt and suspenders to reduce your liability, because there is no insurance coverage. But if you decide not to do it, I'm okay with you not having a waiver. I still do recommend the pool monitor, because of the, basically you've got these rules that Governor Abbott is requiring you to enforce, and I want to make sure you enforce them so that you're not held liable down the road in the event the government decides to come after you with a fine or something along those lines. Or, somebody catches COVID and decides to sue you. So the follow-up, what if it is a smaller community, 100 homes or so? Maybe it's possible to do it anonymous. It really is how your community is going to respond. Question from Leslie. Can the board create common area rules by email, not in an open board meeting? Oh, Leslie, good question. So Chapter 202 of the Texas Property Code can answer that one. And it says that in order for an association to be able to enforce a rule, you must have it recorded. So number one, it has to be recorded in the real property records in the county where the property is located, number one. Number two, 82.070 of the Texas Property Code for condos formed after 1194, you have to give a paper notice with a copy of the common area rule to your entire community. So you've got to do it for condos. And then for single family communities, 209.0051 of the Texas Property Code requires that you adopt any kind of policies, rules, governing documents in an open meeting for which proper notice was sent. So the answer is, Leslie, no, you cannot. Next question, Pam. Our condo was created before 94 and has no provisions in the bylaws or declarations in regard to virtual meetings. Do we go by Texas Property Code law to hold the meeting? And how do we determine a quorum? So Pam, I believe it's 22.160 of the Texas Business Organizations Code that controls in this instance. And it basically says, if you do not have the email right, you can't use it for virtual meetings. So, Pam, my recommendation to you is get with your counsel. You may be able to amend your bylaws to allow for this email or electronic voting to take place so that you can have a proper virtual meeting. So, there you go. 22.160 Texas Business Organizations Code is the controlling provision for that particular question. All right, anonymous. Advice from another attorney stated that a waiver for access to the pool is invalid based on the fact that the homeowner, and I'll do the air quotes, owns the pool, since they are not receiving anything by signing the waiver. Can you clarify? So if you're in a single family community, the owner does not own the pool. It is actually owned by the association. The association is the owner, not the owner. The owner only has easement rights subject to reasonable rulemaking authority. So in order to be able to use the pool, you have to follow certain rules and regulations, one of which is the waiver. So that's for single family. Rolling over into condominiums, you're right, the association does not own the pool. It is owned, in common by the owners. Each owner owns a sliver of the pool. So the owner doesn't technically own the pool in total. It is owned in common based on percentages amongst all owners in the community. But regardless, 82.102 is very clear, saying that the association has the authority to adopt rules and regulations, and in this instance, waivers governing the use of the common areas and more specifically the pool. So the other attorney, I see the argument. Look, I see this waiver argument in terms of validity of the waiver. Look, at the end of the day, a lot of the waivers can be difficult to enforce, but waivers can be successful as a deterrent. So it is basically a deterrent for those owners who are thinking about suing the association over a COVID injury and decide not to do it. Why? Because they have signed a waiver. We have received advice from multiple attorneys and multiple insurance carriers and insurance adjusters indicating that a waiver is a good idea as another belt and suspenders. But again, anonymous, I see the argument from the other attorney. Another question, does a COVID policy for pool need to be recorded? Yes, it does, anonymous. Another question from Sharon. Example for my COVID rule would be reducing population, adding no guests, wearing masks, swim at your own risk. Yeah, so Sharon, we had a webinar maybe a month or so ago that should be posted on our website that gives some suggested language, number one. Number two, CDC provides a lot of guidance on pool rules, but ultimately, get with your counsel. It's really not too expensive to have him or her assist you with adopting some COVID pool rules for the interim, and they can be worded so that they activate while these COVID restrictions are in place, and then the pool rules actually deactivate when everything gets lessened. Excuse me. All right, so that's it for the Q&A for now. Let's see if we have any. I don't see any hands up. So next question. An HOA that I manage is going through a transition from the developer who will deed away his remaining lots within the next few months. The developer has already converted its Class B status to Class A status. The new homeowner board believes they need to do an audit of the developer transition. Since my management company has managed the dues collections and accounts payable and financial reporting since the developer filed the articles of Inc. 8 years ago, is an audit recommended? Has your firm ever conducted an audit for an association going through a transition? So an audit of the accounts, and I'm by an accounting firm or a CPA. Our law firm doesn't offer that service, but let's assume this is single family because you use the term HOA. Audits are not required by law. So unless your governing documents say otherwise, you do not have to have an audit performed. If you're a condominium, you're required to have an audit. and potentially by a CPA. But is an audit a good idea? You know, it really depends on the community, but I don't necessarily think it's a bad idea to make sure you have all your ducks in a row. And, you know, look at the pricing. Many times it's not that expensive to get it done. So again, belt and suspenders, it may be a good idea to see what kind of financial health the association is in right at that transition period. So I am okay with it. Let's see here. We've got another Q&A before we move on. Pam, just want to make sure I understood the question of the annual meeting quorum. If holding virtual meetings is not referenced in any of our condo documents, then a change in the bylaws is required to hold the virtual meeting. In our case, a change in bylaws requires a large quorum. Does that mean virtual meetings cannot be held? So state law says you can have a virtual meeting, Pam, but in relation to voting virtually or by email, that is where 22.160 of the Texas Business Organizations Code comes into play. So Chapter 22 gives you virtual meeting authority, but if you can't vote, is it going to do any good? If you can't participate virtually, then you're kind of in trouble. And I will say this, Pam, even though your bylaws may require a vote of the members to amend the bylaws, you may still be able to do it. There's some sections in both Chapter 82 of the Texas Property Code and Chapter 22 of the Texas Business Organizations Code that gives the board, regardless of what the bylaws say, the authority to amend its bylaws. So the board may be able to do it, even though the bylaws say something a little different. So again, get with counsel. That could be a good option for you. All right, let's go on to the next slide.
Hey,
Swim at
Clint,
your own
real
rate.
fast.
Yes, sir.
Miss Wass has had her hand raised she's having difficulty keeping her hand raised, but she has it raised.
Okay, Allison, Miss Wass, you are up.
I kind of kept, I didn't want to irritate you by having it up the whole time.
No, I'm sorry, Allison. I just missed it.
That's okay. My question goes back to the virtual annual meeting. What if your documents say that you must take nominations from the floor? How do you do that with a virtual and then take the votes?
It's a good question, Allison, and needless to say, it's a little bit difficult, right? So Allison's community requires nominations from the floor. So the question is, how in the world do you do that virtually? The answer is it's possible. There's software out there where you can allow people to do exactly what we're doing right now. So you would have your monitor, whether it'd probably be good to have a manager or a manager team member monitor the hand raises. You open the nominations from the floor and you say, if you have a nomination from the floor, please raise your hand. Any kind of hand raises, you would unmute that person in the order that the hand raise is received. You would ask them to state who their nominee is. And then you would need to confirm that the nominee is actually present at the meeting. So then you would say, Jill nominates Bob Jones. And you say, Bob Jones, if you are on the call, please raise your hand. You would wait for Bob Jones to raise his hand. You would unmute Bob. Bob, do you accept the nomination? I accept the nomination. Okay, then you advise everybody that Bob Jones can now be voted. So you get through that whole process, and then you close the nominations from the floor. Well, now you can actually allow for the virtual voting live in the meeting. So, you should be able to set up a custom button where they press the custom button and then they type in Bob Jones's name and then they cast their vote. So Allison, it is possible, but as you can imagine, everything I just went through, it's, there's a process, but a very good question. All right. Going back in, swim at your own risk pools. How do you recommend monitoring them? There's a multitude of ways of doing it. We've got kind of the gatekeeper at the front of the gate where they come in, they drop off their waiver or whatever the case may be. Maybe they provide provide their name to the monitor, and the monitor writes the name and address and phone number down or email down for the owner to confirm, you know, Bob Jones is Bob Jones, and then they go and use the pool. That's one option. Option number two is you allow them to write all that information in with the monitor monitoring it, and you would have two stacks. You'd have a stack of clean pins, marked clean pins, a stack of dirty pins, marked dirty pins, and then you'd have your monitor clean the pins every so often. We've had electronic where you know, unlock the key fob for people who've successfully made a reservation. There's a lot of reservation systems out there now that you can use. So there, you know, there's a multitude of ways to effectively monitor the cap and the social distancing. It really is dependent upon what works for your community association. And that's kind of size and budget and all that other good stuff. Okay, owners are threatening to go to the media if we have not opened pools. Is this something we should worry about? You know, if there are threats and it's just getting worse and worse and worse, then maybe a town hall or an e-blast out to the community to explain why you're doing it, why you're doing what you're doing is a good idea. And if they want to go to the media, they're going to go to the media, and hopefully the newscaster is going to reach out to the association or management company so that you can give them a response as to why you're keeping it closed. Look, it's difficult. I mean, we've seen what we have literally seen what has happened with a reopened Texas. We have seen a massive surge in COVID-19 cases since Texas has reopened. I mean, I think a lot of our metropolitan areas are now in the top lists for the nation. So, you know, I don't know how much sympathy owners are going to be getting from the media, from, you know, news media, as it relates to an association's decision to keep the pool closed for a little bit longer. But a good question. All right, next question. We use a standard sign-in sheet at the pool that asks for the resident's name, address, number of members, and number of guests and guest name and address. The concern that was noted was the collection of personal information. This particular resident is insisting we don't need to do it since there's no waiver. The pool monitoring company says it helps provide some kind of ID in case of emergency if they have to try to ID somebody without proper ID at the pool. First and foremost, it is not personal information. Chapter 209 of the Texas Property Code and Chapter 22 of the Texas Business Organizations Code allows for any owner to request a list with the name and address of other owners in the community. Number one. Number two, anybody can get on the County Appraisal District website and look up somebody's residential address and somebody's mailing address. So resident's name and address really is not personal. Number one. Number two, it is a member-only pool. You're not a public pool. So in order for you to confirm that a member is a member, what do you need? You need the member's name and you need the member's address so that you can confirm that Bob is in fact Bob and he lives in the community. So I don't see that being a valid concern, but good question. And we've got a Q&A that just popped in. Can you better explain the self-help remedy? Self-help, okay. So in the governing documents, it should be in your declaration. That's more than likely where it needs to be. There is a self-help clause that basically says, if an owner doesn't maintain their yard or doesn't do anything in the declaration that they're required to do, and it maybe says, and after 10 days notice, the owner fails to cure that violation, the association can enter upon the property, perform the self-help, and then charge the owner the cost back for whatever it is, and maybe anything related to the self-help exercised by the association. So that, you know, that's the wording roughly. Again, each declaration is different, but it allows the association to go on to the property, normally after notice to the owner, and then perform some task, whatever it may be, to get the property back in compliance. That is self-help in a nutshell. Okay, so here we go. We've got another one. What is the HOA regress if the homeowner refuses the service? Leave the property. Do not breach the peace. Breach of the peace is kind of a criminal term of art, but if your landscaper goes on to mow the grass and the owner comes off and says, you know, landscaper, get off my property, landscaper needs to stop and vacate the property. So what does the association do in that instance? Well, then they go through the typical deed restriction enforcement process. They send their letters, they send their Chapter 82 for a condo or a Chapter 209 letter for a single family letter. That's kind of the final letter. And then they refer it to the association's attorney, and the attorney, he or she, can then send their letter. So you've still got an avenue of relief if you've got an owner kicking off the landscaper for the self-help. So if you get valid pushback, just make sure your vendors leave the property. All right, just a quick side note here. Y'all probably all know this, but we have hardcover or soft cover paper, single family and townhome association kind of cheat books. It's got all the more important code sections for single family and townhome associations. And then we've got one for condominiums as well. If you want a paper one, that's fine. We still have plenty and we can ship them to you. But now they are available for download on our website. So if you look at that link down there, you click on it, or you go to our website. Those property code books are available for download, so you can keep them on your laptop. And it looks like we're at our Q&A. We're right at 1 hour. Sorry again for that 3-minute delay on my part. I got kicked out. Do we have any other questions? I'm not seeing any Q&A pop up. Again, contact us. You have any questions? You know, I practice kind of the 5-minute freebie rule. If you've got a question, it doesn't matter if you're my community association or not. Feel free to give me a buzz. I'm happy to listen and provide you with my thoughts. And again, take it for what it's worth, right? Not getting paid, just giving you thoughts. Governing documents are different, and the law changes as well. But again, still happy to listen and provide thoughts if you need me to. And I'll look one more time. Nope, still no Q&A. So thank you all again, and I hope everybody has a good rest of the day and a good rest of the week. Bye, everybody.